Happy to see all you very interested because lawyers when after graduation, it may be a 5 years course or it may be a 3 years course. So then when they come to court, they more get engaged in this practicing. That is good, but they leave this academic. There should be whosoever is interested to rise in this field. He may be a judge, he may be a public prosecutor, he may be a practicing lawyer. He should simultaneously academic study is required because on academic side, if you confine to academic, but I have noted, I have earlier this we have made mock exercise, mock interviews in Chanke twice. So there are two KS students I have done. I was a chairman also of that. Now we have done this public prosecutors, prosecuting officer. That we have completed yesterday in SR College. So now, what we have noted, the candidates who are coming, they have only academic knowledge because they are mostly the freshers from the law colleges, from law school. Lawyers are very less. Why lawyers are less? They get interested in that, or they leave academic study. It becomes difficult for them to have competition, to write down and who's my stress is that a lawyer should continue academic study while practicing. That is that is needed in order to become a good lawyer, good judge, good public prosecutor. This is now may I start? First, as they have said that I have to start this chapter second, this part second, but I want to give an overview of this Evidence Act. That is summary overview of the earlier. First question is, what is evidence? First question to all, what is evidence? Evidence, or it is, if you go to a definition of evidence, you will find it is either oral or a documentary. Either the definition is, I made it, evidence means and includes. It means exhaustive होगी, includes all statement which the code permits or requires to be made before it by witnessing in relation to matter of the facts under inquiry. Such statements are called oral evidence. Oral evidence, but oral evidence is verbal evidence. That is, and other is all documents including electronic records produced for inspection of the court. Such documents are called documentary evidence. Now when we say the facts, first is now fact. What do you mean by fact? Fact means and include anything, state of things, relation of things capable of being perceived by senses, any mental condition of which any person is conscious. The word is conscience. Now, by this Evidence Act talks about this. There is a question. The evidence the police officers police officer, this investigating officer collects during investigation, whether you consider it as a piece of evidence, whether it is admissible in evidence as it is. No. My answer would be a big no, because there is a collection of evidence. After that, Now I will ask you one question. There is a statement recorded under section 161 of Code of Criminal Procedure or 164 of Code of Criminal Procedure. What is that statement? How it is to be used in a court of law? That is only a recorded statement of a witness. Its authenticity, is subject to cross-examination. This that is before court. Chief examination, cross-examination. You are knowing section 145 of Evidence Act is there. That is this evidence 161. Everything is subject to scrutiny. Now question is by the 130 you might be there is a 118 of Evidence Act. Who is a competent witness? Then competent witness can be anyone. First, there is a child witness. Exception is generally speaking with child witness there is an exception. But child witness is also competent if he understands the thing. There is a competent witness under this Evidence Act. Now, oral and documentary evidence. Now, first primary, whether you will agree with me that best evidence, what is the best evidence a court requires? What should be this best evidence according to you? This is my question, please. Tell me what is the best evidence which is requires to be in a court of law once required. Best evidence is a primary evidence. It may be a oral evidence. It may be a documentary evidence. The preference is always given to primary evidence. This is a law and it is considered direct. It is a direct evidence. Sometimes direct evidence is not available. Then now next question is whether hearsay evidence has certain value. Now question is whether hearsay evidence. Hearsay always it may be a oral evidence, verbal evidence. It cannot be a documentary evidence. Assume of somebody says that I have seen particular time it was its content and I want to give the brief whatsoever is written in the document. That is also an indirect evidence. That is also hearsay. No document is not available. He is saying I have seen the particular document. This was written in this document. So main concentration is now what is your reply? Whether hearsay evidence is admissible or not? Please tell. Anybody knows? There is a hearsay evidence. The hearsay evidence is not cannot be avoided. It is a part of Evidence Act. It is a part of Evidence Act. You write from this section 6. Right from section 6. That falls on relevance facts. The res gestae confession. You go on reading, I think up to this dying declaration is also hearsay evidence. Generally speaking, यहाँ पे हम जब questions आते हैं, this is a hearsay evidence. You can't read that evidence. Hearsay evidence क्या है? Chain of evidence. When chain है. Chain मतलब for example एक कई बार क्या होता है? Last scene theory है. एक घर में मियाँ बीवी हैं, तो लॉस दोनों हैं, तो वहां पे कोई डेथ हो जाती है बट इन बिटवीन टू, तो क्या हो जाएगा? तो वो आपको इंटरेस्टिंग सुनाऊंगा गुलमोहर होटल का, वहां लास्ट सीन थ्योरी थी, जहाँ सेकंड एडिशनल सेशन जज थे। तो वहाँ उस केस में क्या था कि एक लड़के, जो राजस्थान का एक लड़का, वो मैरिड था, और लड़की वो उससे उसके लिव इन रिलेशन में थी दूसरे जो। तो दोनों होटल में माता वैष्णो देवी था। तो वहां एविडेंस लास्ट सीन की थी कि भाई ये होटल से गए शाम को बाहर घूमने के लिए। तो जो एविडेंस आया, जो एज ए जो लीड हुआ एविडेंस फिर आया, और जो वहां पे थे, जो रिसेप्शनिस्ट थे या उनको बेटर थे, तो उन्होंने सिर्फ गर्ल को देखा उस वक्त आते हुए और कमरे में जाते हुए, तो लड़के को नहीं देखा। तो फिर क्या हुआ, वो लड़का एक्सक्लूड हो गया। लास्ट सीन दोनों नहीं थे उस रूम में, तो चेन ब्रेक हो गई। ये चेन जो है, ये सर्कमस्टांशियल एविडेंस जो है वेरी इंपॉर्टेंट। और क्या कहते हैं, तथ्य खुद बोलते हैं सर्कमस्टांशियल एविडेंस इज मोर। अगर उस साइड, अगर रिवर्स देखोगे तो सर्कमस्टांशियल एविडेंस जो है, कहते हैं कि जो हालात हैं वो गलत झूठ नहीं बोलते, आदमी वह झूठ बोल सकता है। वर्बल एविडेंस कैन बी डाउटफुल बट नॉट सर्कमस्टांस। कैसे, लेकिन इट डिपेंड्स अपॉन द प्रोसिक्यूटर or a judge how he appreciates. Appreciation is very difficult. For a lawyer, I generally say, wherever I go, I generally say, for a lawyer, two things are very difficult. What? The pleadings, writing of a petition, and cross-examination in criminal case. Main is cross-examination in criminal case. You will find in this, maybe a small criminal case of a theft case, or the cross-examination of the witness, very important. And pleadings. You may write a petition, pleadings, anywhere, though you will, it will come. For a judge, decision making, other things can be done by the readers, others, but decision making he has to do. Decision making is very difficult. Why it is difficult? In a criminal or civil case, then appreciation of evidence is very important. How it evidence, this is, there is a, not always you will find direct evidence. Some there is a direct evidence, such as opinion based evidence, and some are circumstantial evidence. All these are to be bring together in order to acquit the accused or convict the accused. Nothing can be ignored. Everything is required to be seen. Now, just I want to refresh your memory overview I am giving with regard to this